face the difficulties of today and tomorrow, I still have a dream. It is a dream deeply rooted in the American dream. This nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident.
Hello, and welcome to Episode 9 of the Policy Dialogue Series with alumni, staff, faculty, and students from the University of Maryland School of Public Policy. The views expressed do not represent official positions of the school or alumni network. Our goal is to discuss specific policy solutions that can address and solve the current local, national, and international challenges we face. We are recording this on November 24th, 2020, and my name is Evan Papp. I graduated with the class of 2011 with a focus on international security, economic policy, and I'm the executive producer of Empathy Media Lab, which creates content on labor, political economy, art, and culture. Joining me tonight is a fellow alumni, Anora Wang. Anora is an associate attorney of Davis Wright Tremaine LLP, and she represents clients in complex antitrust litigation. While pursuing her law degree, Anora worked as a research assistant for the Global Antitrust Institute at George Mason University. Prior to attending law school, she worked at a biopharmaceutical company where she gained experience with intellectual property issues related to patenting and licensing technologies in the United States and China. Anora is an appointed leadership member of the American Bar Association's Antitrust Law Section, and she regularly hosts the podcast, Our Curious Amalgam.
Yes.
Speaking with global experts on antitrust, competition, consumer protection, data, and privacy. So, good seeing you. It's been almost a decade since last seeing you. And can you talk a bit about what you studied at the University of Maryland School of Public Policy?
Yes. In a policy school, obviously I studied policy, but with a little bit of specialization, or I guess focus on environmental policy. I was also working at the time as an intern, sort of at think tanks. That's very much about tackling the global warming. I guess you don't even call it global warming, but climate change issues at the time. I realized I was not really making a difference. as anyone who in their early 20s would want to do, you want to change the world for the better. And that's what I set out to do. And I realized I really didn't have the kind of specialized knowledge or skill like in law, in finance, or technology. And then that sort of long story short, triggered me to think about have another degree in law, which I did. Now, again, long story short, I find my interest in antitrust which is like a very nice area that combines all of my interests, like policy, business, law, technology, all in one. So that's how I got my job, what I do currently.
So for people who are not familiar with antitrust legislation and policy, could you discuss what is antitrust and why people should care about it?
For sure. For one, it is not what you played the board game Monopoly. Let me be sure. It's not about that. But I am aware there is actually another board game called Anti-Monopoly. You can buy it. It's pretty fun to play with. But that's not what it is. Outside of US, antitrust is called competition law. That's true in the EU and in a lot of other jurisdictions like China. China actually is called anti-monopoly law. Another term, but usually competition law is the generic term. So as the name suggests, it's about enforcing laws that preserve the competitive process, not so much protecting your competitors or now I think there might be some voices saying different, is it about preserving smaller business or choices in the marketplace, but after over 100 years, at least, it's shaped up in the US about preserving competitive process.
And so when you were studying antitrust in law school, what are some of the most relevant precedent-setting antitrust cases that continue to shape the current negotiations around antitrust?
Yes, I think so. Oh, I forgot to give a disclaimer. I should say that anything and everything I say here only represent my own personal view. It doesn't represent any of my client, my colleagues, or my firm. But back to law school, I have to say I did not take one antitrust, but like 6, 7. And then plus some sort of seminar type writing courses. So it's really hard to narrow it down to 1 or 2 cases. But I have to say the most relevant to what is going on, I guess a lot of discussions with technology or big tech, what do you call it? Or, essentially try to reshape what the antitrust enforcement and policy is about. I guess you would want to go back to 2001. That's the DC Circuit case of Microsoft, US versus Microsoft. So that's in the space, what we call Section 2 space. Section 2 is the Section 2 of Sherman Act that's essentially dealing with monopolization or attempt to monopolize. And a lot of tech cases or allegations against the technology companies is in this space. So you would want to go back to what exactly is the last major case that you have seen in this space. And then DC Circuit is very wisely pointing out this is all under rule of reason. What is rule of reason is essentially that you have to go through the facts. It's facts intensive, case by case. You cannot categorically saying this certain conduct is illegal. There is another provision in the law, which is Section 1 of Sherman Act, that's dealing with that. That's usually about cartel, price fixing, allocating markets and customers by making agreements. So that's essentially, those are per se illegal. And then a lot of the allegations against technology companies, I guess, relate to what's most talked about nowadays, the current debate and conversations is usually in the monopolization, the Section 2 space. And then there you really need to go into each specific case, and then you really need to examine the particular allegation, the nuances of the conduct. So I think that's a case I would encourage you want to read if you're really bored and you want some weekend reading.
Well, we're about to go into, I think, the 2020s are going to be filled with a lot of antitrust cases and focus, specifically on what's happening with tech right now with Google and Facebook. And what I'm always interested in, on one side, you have capitalism, in the big quotes of trying to improve and increase trade. Yet oftentimes the winners in that battle of that competition will become the major players and market makers, and eventually become, if not cartels, monopolization. And so there's that constant tension that's going on between the actual competition and then what can be deemed as antitrust. So I guess during a litigation, to just better understand for people like me who've never worked in a law firm, how do you actually determine the intention of a price fixing or the creation of a cartel? You mentioned before we started about data and trying to understand data more. And where is there a threshold where maybe the government says, okay, this is a clear case of anti-competitive practice?
Yeah, for several points to address what you just said. First of all, there is a clear division between Section 1 and Section 2. Essentially, those per se illegal conduct and something that you have to examine under rule of reason. So cartel, that's per se illegal. That's not even something that you can rebut with evidence of efficiency. You cannot say it's more efficient if I collude with my competitor. That's just not, that's a non-defense. Those are per se illegal. And then for those things, agencies around the world, not just US, they're very aggressive, including Japan, Brazil, a lot of jurisdiction that picked up in the past, I guess, 2 decades. They're very aggressive. They use something, you can actually check out one of my last episode in my podcast. One of the economists just talked about this. They use a lot of econometric tools, something called screening tools. They would look at whether the prices, for instance, let's say there is a certain market for gadget A, and then there's a clear change of demand, but there is not a corresponding change of price. And then people economists who are either hired or they're just out of curiosity, they're going to be very I guess puzzled by that kind of irregularity. in what they have seen in data. And then agencies do the same. They would very, very much looking into these kind of irregularity. And then if they do have, I guess, enough data, they're going to challenge, they're going to open an investigation. And then once you have been found colluding or manipulating a market through either, like, you know, there were cases like people actually doing that like manually a lot for a long time, like old school smoke-filled room kind of thing. Or like, you know, what they call concerted action, like, you know, you are just using algorithm now, like, you know, with more data and technology involved, following the pattern, following the pricing of your competitor. So that's a little bit of your gray area, like, you know, for investigation, right? Are you actually colluding, or are you actually, or it's not? It's just like, you know, robust competition. But once you're found, I want to be clear, those are per se illegal. They're not something that we have talked about that would be examined under reason. But I do think there are, so a lot of antitrust cases are involved revolving around mergers and acquisitions. So those are not so much about conduct. They're about forecasting, basically. Like, you know, if two firms are going to merge, is that going to affect the price? Is that going to, you know, enhance their market power to the extent they can unilaterally raise a price significantly? So those, you, that's different. You are not looking at something like, you know, data was talked about, like, you know, scanner data, but you're really demanding more economic work. You're gonna consider what is the relevant market, and you talk about the relevant goods, relevant product market and the relevant geographic market. Then you see whether these two firms are the two firms in town, and then they, if do merge, can increase the price significantly. So that's different. That's another area that's not so much per se illegal or something like we just discussed about other conduct. That's a lot more about economic work.
So have you seen a shift from looking at maybe the domination of a market from a different corporation, from focusing on, say, this corporation has 70% market domination, so maybe they can distort prices, to shifting from that view to looking at the consumer and saying, well, actually, as long as it doesn't affect the consumer, then it's okay for this market domination. And I mean, I could think of some online sellers that could make the argument that on one side, they have a huge share on the market, but on the other side, they've lowered the price. And so they can point that out, that actually the consumers aren't being affected by it.
So quick response to that is that big is not bad. If you have been able to obtain, I guess, a lot of what do you call power, but I would say just like, you know, you have a lot of share through robust competition. Like, you know, you just invented, like, you know, a better gadget than your competitors. And then everyone is sort of like, you know, switching to this, and then you grow into a firm with a lot of share. That's not illegal, right? That's what antitrust is about. It's about preserving the competitive process. It's about, like, you know, promote that kind of robust competition. What is getting anyone into legal trouble is that whether you're using certain means to maintain or create your market power, your, I guess, dominance, what you would call, illegally. Like, you know, are you, I guess, I cannot give you any good example because, you know, it might relate to any case that I'm dealing with, but outside the US, in EU, essentially, there's something called abuse of dominance. So as you can understand from the term, it's not the dominance getting you into trouble, it's the abuse of it. So you're right, a lot of firms can grow into a certain size that they're essentially the biggest player in town, but they're also doing good things for consumers. They are lowering the price, they're increasing the output, they're also innovating aggressively. So it's about abuse part that's going to get you into trouble. I do want to add one more thing that I was previously talking about, merger and acquisition. So people like a lot of people might take a different view right now, like saying antitrust in the US need to be more aggressive. And the way to do that is to sort of change the presumptions or narrowing safe harbors or just, shifting the burden of proof in certain cases. Certain people have been advocating that, if there are two big firms and they are over a certain size, their merger or acquisition should be presumptively illegal. People are saying that. People are also advocating some certain other ways for agencies to essentially easier to get their cases in court, and then shifting the burden essentially back to parties that saying now you have to prove that you are not actually doing anything anti-competitive. I have satisfied what we call prima facie, essentially the initial burden. So that's something people say. I guess there are merits into these types of views if you think the current enforcement of antitrust law in the US is under what's desired, what's the optimal level.
Thank you, for helping justify that for me. So you host a podcast called Our Curious Amalgam that focuses on antitrust competition, consumer protection, data, and privacy. So how did this podcast come about, and what is your favorite episode or guest for others to check out?
Yeah, so I'm actually very fortunate. I believe I'm the youngest, I guess not the youngest, the most junior person who is working on this project. So that is sponsored and actually organized by the American Bar Association Antitrust Law Section. That's a group of very, very impressive lawyers. People usually have practiced in this field for 10 years, 20 years, 30 years. And then I got involved because when I was a law student, I might have been the most loud one who is saying, I want to do antitrust as a law student, being involved with the group of lawyers who is behind this project. And then that's the very time, ideas about reaching out to younger people, reaching out to non-lawyers, or reaching out to lawyers who don't do antitrust but who are interested, or anyone, just the general public, through some non-traditional routes. Lawyers are usually very old school. People usually still read for information, right? So a lot of things usually is delivered. Content is usually delivered through publication. And then podcast is a new format that this group is considering. And then they looked at me essentially say, hey, you're a millennial, you can tell us, is that gonna work? And then I said, yes, I think because I'm myself is a big consumer of podcasts, I might as well be a producer of one. So I want to be clear, Our Curious Amalgam is not just about antitrust. It also covers consumer protection, data, and privacy, which is actually somewhat different. Some things that we talked about, data, companies are able to gather a lot of data, and then is that somehow creating antitrust concern? Yes, for those, I'm not saying yes to that question, but yes, this is a concern, but this is the area that, antitrust and privacy and data can intersect. But there are other issues, very much you asked me about my favorite episode. I'm going to mention there's one called Is it not always not fair? I'm embarrassed that I cannot recite the title, but it's about what kind of advertisement can get you into legal trouble. I think I liked about that episode because it gave me some very, very amusing examples. You cannot, for instance, advertise that you're selling faux fur, non-real fur, but you're actually selling fur. I would not understand why would a firm was doing that, but apparently that was a real case. So certain things that can get you into trouble by misleading consumers, but that's very much in consumer protection realm, not antitrust. But they're both under FTC enforcement umbrella.
So definitely put that in the show notes to link back to that as well for the podcast. So you also recently published more than a dozen short articles covering antitrust, intellectual property, and trade secrets from around the world. Is there an article that you could highlight about essentially about what it's focusing on and why it's important?
For sure. So the operative in what you just said is short. So they're very short articles. They're usually 2 to 3 pages covering changes in policy and changes in law. And given my background, I grew up in China, and I also have a lot of connections there. And I also closely watch changes policy and law there. So, and that's an underserved area here. People do not understand so much what's going on in China, and it's actually very aggressive. Recently, there is a draft guideline that's put out for comment dealing with digital economy. That's not something that I know it's hot here, but there is at up to this point not a specific antitrust enforcement guideline targeting a certain set of tech companies, but China has just put out one. So these short articles that I wrote, they're essentially of this type. They're covering recent changes and highlights the changes, and then what could this mean for business and individuals. And then sometimes, like, I do talk policy, but which I avoid to, because when you do get into legal practice, you do not want to get into too abstract fight when unnecessary. But one thing I would want, you asked for a specific piece, I would highlight, that's actually not so recent. It was written in 2018 when I was in law school. I was only a summer associate at my prior law firm, but I essentially took issue with ITC, short for International Trade Commission, agency getting into antitrust enforcement, where there are antitrust agencies already doing that. That kind of I guess, in my view, improper mixing jurisdiction is not fine. You can go read it. I think it's online. If it's not, send me an email. I can send you a copy.
Yeah, absolutely. And for the short ones, I mean, you're focusing on everything from China and Hong Kong and Japan and the European Commission. And before we started recording, I asked you a little bit about the WTO, the World Trade Organization, and I couldn't find much in way of competition law or antitrust law. And it seems like much of this is being done country to country basis of domestic law, and then obviously trade agreements that you have locked in maybe bilaterally or multilaterally, as in the case for the European Union. But is there an international standard for antitrust law?
There are good principles that, like, many, if not every jurisdiction is borrowing or learning from each other. I think there are areas that you would see a lot more convergence is, I guess, in IP and antitrust. A lot of issues that we just talked about involve whether essentially a patent owner should be licensing its patent under what we call friend terms. That's a long string of terms, but essentially meaning you should be doing that fairly. So a lot of issues, a lot legal fights also arise out of that kind of issue. But there is convergency in the sense that people all think competition is good, like, around the world. People all think, even though there are tension between IP law and antitrust law, but licensing or any conduct related to that should also be serving goals, preserving competitive process. So I don't think there is any sort of agreement that you can find when searching WTO for good reasons. So for instance, there is actually a lot of controversy when a certain agency in any jurisdiction is issuing what we call remedies, essentially solutions or ways trying to fix an antitrust problem, going out of its borders. Right, that could be a problem. So if, for instance, a certain company is sued everywhere, and then country A is saying, to fix this problem, you need to do certain things globally. And then what country B says, what country B, what it means, like, no other country should enforce them, because, ideally your remedy should fix the problem globally. But isn't that essentially taking out the opportunities for other enforcers to look into the competition in their jurisdiction. Again, what we were talking before is that antitrust is very much about the relevant markets, right? You have to look at the relevant product market and a relevant geographic market. For certain things, true, there are things that global market is the relevant geographic market, but not everything is like that. So I wouldn't think it's a good idea to have a global standard or one global enforcer. For that very reason, you need to look at specific markets. Even in the US, you other than the federal agencies, you also have the states that's very actively enforcing their own competition law, or what we call antitrust law.
And then it will obviously affect a corporation that's on the trading floor of that country, or if there is like a market in that country, then they'll just have to follow the competition law within that country. So that
yeah. So I'm sorry, my cat is getting in the camera. I'm gonna move Robin away. but Robin, a little trivia: if you do follow Our Curious Amalgam, there is a fan-based Twitter handle called Our Curious Hat. That avatar is of Robin's.
Awesome.
So what I was going to say is that yes, so each jurisdiction has its own competition law, and this could be a problem for certain firms. Like, if you, let's say in the merger and acquisition space, if two large companies who are doing business everywhere trying to merge, you are legally required to notify, I don't know, it could be a dozen, it could be more than a dozen jurisdiction, agencies in these jurisdictions. That could be a very expensive process, and not to mention very laborious.
Yeah. So in closing, looking into the future of antitrust, what are some of the global trends that you're seeing, and where are there risks and opportunities?
So I think one trend we actually talked right before our actual recording is that cartel enforcement is very aggressive. People are asking, I think this is also one of the episodes that we talked on a podcast, is that, is cartel enforcement down, or, not as aggressive? That's actually not true. I think a lot of jurisdictions are catching up. They are actually maybe arguably doing better than the US. They are using data to detect more potential manipulation or collusion, data that's just not available here. And then certain countries like Japan, Brazil, they have their own tradition dealing with what we just described, old school smoke filled room kind of cartel problems historically. So they're very aggressive on those ends. Another trend that we're seeing, and needless to say, if you're reading news, tech or people are just generally concerned with I guess economy or marketplace, where you can see a lot of what we call network effects. Essentially, you just described, you have to be large enough to be effective, right? If, say, a platform, if I'm not on it, you're not, and none of your friends are on it, it serves no purpose for you to be on it. So certain products in certain markets, it just works that way. And people are concerned in these markets, essentially, would you be seeing a tipping point, and then after the tipping point, there is going to be one or two big players. People are concerned with the power issue, and potentially would that affect democracy? Those are arguments that I do not make, but you can see they are very popular.
Anora Wang, thank you so much for your time.
Thank you.